We're on the record.
We're on the record in case number 4:17 CR 3038, United States of America versus Michael Wayne Parsons. Counsel for the government, please enter your appearance.
Good afternoon, Your Honor. Jan Sharp appeared on behalf of the United States.
And Mr. Michael Wayne Parsons is also present along with his standby counsel. Please enter your appearance as standby counsel.
John Vanderslice as standby counsel for Mr. Parsons.
Objection. I am Ambassador Michael Parsons. I am not the corporate entity or trust Michael Wayne Parsons that the indictment is against.
And I have already ruled that you are Michael Wayne Parsons, the defendant who is named in the indictment. Now we're going to be taking up the detention hearing at this point.
And I would object because I am the live man. I'm not the corporate entity, and the United States printing style manual clearly articulates that in all court documents, names in all capital letters reference corporations or trusts.
All right. Mr. Sharp, you may proceed.
Your Honor, if we didn't cover this at the last hearing, I would ask the court to take judicial notice of the pretrial services report and of the testimony of Monty Chaplesky that was given during the identity hearing.
I would object. I've never been provided access to those to review.
Okay, the pretrial services report. Mr. Vanderslice, do you have a copy of that?
I do, Judge.
All right. Pretrial services report, I believe in this case, is essentially your criminal history.
I do somewhere. If you just give me a moment. I'm sure I've got it.
I can.
And Your Honor, if I may ask, those documents that I presented as exhibits, those are the only ones that I have like those. If there's a possibility to get a copy of those.
You will have a copy before you leave the building. I promise.
Okay, thank you.
Mm-hmm.
And other than that, anything in the file,
in fact, what we may do is make a photocopy and keep the photocopy and give you the original, because I don't know if I know how to make color copies.
Well, Mr. Vanderslice did give me a couple of copies of things from the file 2 days ago, but it looked like there might be 11 different things filed in there, so maybe I'm missing about 9 of them.
And Judge, I can tell you, I spoke. I'll be happy to provide Ambassador Parsons with all of the documents that I have that have been filed in his case. And I should note that I spoke with Mr. Sharp out in the hallway during our break. He had asked to be able to give me the Rule 16 discovery, and I told him that would be fine as long as I'm able to photocopy that and provide Mr. Parsons actual copies. Typically, there is a prohibition against defense lawyers giving copies of the discovery to our clients.
Okay.
And so here, I just want you to know that that's what I intend to do.
All right. Hang on just a second, sir. I'll give you a copy of your pretrial service.
Actually, I just gave him a copy.
Oh, you did?
My copy, yes, Judge.
Thank you. All right. I will. Any reason I should not take judicial notice of the pretrial services
Yes,
report?
Your Honor, I object to this because this says at age 29 that I wrote a worthless check in Tipton County, Tennessee. I was nowhere near Tipton County, Tennessee at the age of 29, and I certainly have never written a worthless check in my life. It says disposition not received, but this is insane.
All right. Anything else on this document that you object to? Candidly, I probably wouldn't go back all the way to 1991 and figure out what to do with that information anyway. So,
here again, it says there's a charge of financial responsibility law. As far as insurance on vehicles, if that's what that's talking about, I don't think I've ever gone a day since I was 17 without insurance on a vehicle.
Okay.
And this issue of aggravated assault with injury, disposition not received, the grand jury dismissed that fraud because this was a fellow that shot at me and my wife, shot and killed my dog, and they charged me with assaulting him for telling him to stop.
Is that January 15, 2004? Is that what you're saying?
Yes, ma'am. That was the grand jury dismissed that. That's illegal for them to even have that on the record. It was supposed to have been expunged because the grand jury came back with a not true bill.
Okay.
That's-
Anything else in this document that you object to?
I mean, when I was a bumper violation, it was dismissed. Everything else has been dismissed. This worthless check is a fraud. The dogs running at large was a fraud. They dismissed it, and the aggravated assault was dismissed by the grand jury because I assaulted no one. I was assaulted, actually. My dog was shot and killed by a man. It was just a nut. And, of course, that's what they do in Tipton. That's evidence right there of the abuse of power that these people are committing every day.
You'll see in the final column, the pretrial services office is not stating that you were convicted of all of these things. They are listing what appears in your criminal history.
Well, the problem I have is that when the grand jury comes back with a not true bill, they're supposed to strike it from the record completely. It's not supposed to show up anywhere, at least by the statutes in Tennessee. I don't know about Nebraska.
All right. Anything else on this document?
I don't know about this. Says warrant for failure to appear 2 counts in 2009. I don't know what that's talking about.
Okay.
I've never been charged with failure to appear or gone to trial on a failure to appear other than this last time, and that's because I didn't have a notice to appear. Let's see. Okay, and the possession of a weapons charge, which stems from this whole thing from 2014, it says right here it's been dismissed.
Correct. So you don't object to the fact that, I mean, it's saying the counts were dismissed. That's true information, correct?
Right. I'm looking for a felony conviction here that there's not one, and I'm supposed to have been convicted of a felony to be here today, I believe, is the issue.
We're not deciding that today.
It's not even on here from 2009. There's no conviction for a felony in 2009.
Okay.
So
anything else you're objecting to on this document?
Well, if this is correct, then there's no listing of any felony convictions from the time prior to the arrest of this charge, or the indictment, which was April the 19th.
And we're not taking up that particular type of motion today. Today's
But
motion.
Your Honor, on its face, if they don't have a charge of felony to prove that's the basis for the charge, I move to dismiss the charge and release me immediately.
The pretrial services report is not the government's evidence. The pretrial services report is the court's, and this is what the court found.
And I agree. That's what's happened is, Your Honor, and you have a copy of the reasons for judgment. The state of Tennessee, the governor of Nashville, may have exonerated me based on that reasons for judgment. That might be why it's not there, because I recall talking to a friend of mine that was a deputy in Memphis, Shelby County, who pulled up my record back in December of last year, and he said that, quote, there's nothing there on you anymore. It's all gone. So maybe the governor signed your exoneration.
Okay. I have stricken the matters that you have requested that I strike. I'm printing a version with the stricken matters on it. We will make that an exhibit in this case. Other than that, the pretrial, with those strikeouts, the pretrial services report is received. Any additional evidence by the government?
Oh,
all right. Any evidence by the defendant?
This one here, it says May 16th, 2015, warrant served, further status, disposition not served, convicted felon possession of firearm. That's false. There was no anything with possession of a weapon. That's the day I got out of prison.
All right. I've received the pretrial services report with the strikeouts that you requested, or with the modifications that you requested. I'm not going to be taking up any motion to dismiss today.
Well, ma'am,
we'll mark that as Court's Exhibit Number 1. Any evidence by you on the issue of the detention?
Me?
Yes.
Yeah, this thing is totally wrong. Yes, ma'am. If I can find it here, one moment. And Your Honor had informed me that this court follows the United States Supreme Court decisions as well as the United States Code and the Constitution for the United States, correct?
Correct.
Okay.
We are bound by the law of the United States.
Thank you, ma'am. Okay. The United States being a signatory to the Vienna Convention on Diplomatic Relations, it's an undisputed fact that I am the ambassador of the Chilcotin Indian Nation. And via the Montevideo Convention, my status as a diplomat need not be recognized by the United States in order for this court to be bound to the treaty that the United States of America is a signatory to, which states that they are bound to those treaties, and under Article 3, the political existence of a state is independent of recognition by other states. Even before recognition, the state has the right to defend its integrity and independence, to provide for its conservation and prosperity, and consequently to organize itself as it sees fit, to legislate upon the interest, administer its services, and to define the jurisdiction and competence of its courts. They have done such as that. They have created their own international court. It is recognized by The Hague in Switzerland, Netherlands. I've never been there, so I lose track of the location of these courts. That is the Netherlands. The existence of these rights has no other limitation than the exercise of the rights of other states according to international law. In Article 4, states are juridically equal, enjoying the same rights and have equal capacity in their exercise. The rights of each one do not depend upon the power to which it possesses to assure its exercise, but upon the simple fact of its existence as a person under international law. Article 5, the fundamental rights of states are not susceptible to being affected in any manner whatsoever.
Okay, Mr. Parsons, let me ask you something. Do you have any evidence to oppose the government's motion that you be detained?
Yes, ma'am. The fact is that as an ambassador of another nation under the Vienna Convention on Diplomatic Relations, which the United States of America is a signatory to, Article 29, a person of a diplomatic agent shall be inviolable. He shall not be liable to any form of arrest or detention. The receiving state shall treat him with due respect and shall take all appropriate steps to prevent any attack on his person, freedom, or dignity. And Article 31, the diplomatic agent shall enjoy immunity from the criminal jurisdiction of the receiving state. He shall also enjoy immunity from its civil and administrative jurisdiction. That clearly states that the United States of America recognizes the necessity of protecting the integrity of ambassadors from foreign nations as well as the United States of America's ambassadors equally, so that everyone can freely move without the fear of their ambassadors being locked up. And that was the intent of such by the United States of America as being a signatory to this. Furthermore, under the United States Code, Chapter 28, Section 1330, it references that all ambassadors are immune from prosecution in this country. Therefore, that renders this whole matter moot, whereas the United States can't have standing in a claim for which they've already waived their right to standing via these treaties. On my first notice of this indictment 2 days ago, December 18, 2017, the indictment was filed in April of 2017, some 8 months ago, have expired. And bringing me before this arraignment violates the court's own rules requiring that we be brought up immediately if incarcerated. Now, though Tennessee had me there, the state of Nebraska had me for well over 3 months. March 22nd, I believe, is when I was transported. And it's interesting that the court in Beaver City, Nebraska had a pending extradition hearing, and that somehow or another Tennessee was allowed to come up here to Nebraska, kidnap me from a prison without the proper credentials, because the court's jurisdiction still stood at that time that they had the right to do a extradition hearing and determine whether I was to be extradited, because I was fighting extradition. I was trying to go back to the Chilcotin Nation for a business meeting relating to my position as an ambassador, assisting in the negotiations for the Chilcotin Nation's timber deal with a company in Tennessee and their timber with an international buyer for their benefits of developing that resource. My inquiry into the existence of a bond for this claim against me by the United States of America Corporation, I'd asked, was there a bond? I wasn't referring to a bond for my release. I was asking for a bond against the complaint. And I'd ask again, is there an acceptance bond or a bid bond presented in the court record in this matter?
There is not, and there is no requirement that there must be under U.S. law.
Is this considered a tort, or is it considered a commercial crime? I wasn't really clear on that.
It makes no difference. It's a federal crime.
Is it a tort, though, or is it a commercial crime?
If it went into a civil case, it would be a tort. This is not a civil case. It's a criminal case.
Right. As I understand it, that there has to be a contract if it's a crime under statutes, which are corporate policy. They're not law. They're under color of law.
That's a misunderstanding of federal law.
The federal law stipulates it's a corporate policy.
You are incorrect.
The other issue was that this indictment has been altered, which I believe by the rules it makes it void, because this indictment can't be altered from its original once whoever's been, their name's been obliterated as a foreperson signs it. It can't be altered, and there's no way to know whether or not they meant to say February or January. And I presume this is the government's attorney's initials up there.
The indictment on its face, and I can view it right from the court here, is perfectly acceptable.
Well, the concern I've got also is that the indictment does not state a cause by which relief can be granted. It pertains to, and it says twice, international commerce. But under the United States Constitution, Article 1, Section 8, it says, it only grants Congress the power to regulate commerce with foreign nations, among states and Indian tribes, not the people or between tribes.
And your point?
The United States of America doesn't have standing because they don't have authority over interstate commerce relating to we the people or between tribes.
You are incorrect. You are wrong on the law.
And what law is that? I've looked it up. The Constitution is the foundation of the law. You can't pass a statute that circumvents the Constitution. Or is the Constitution no longer the supreme law of the land?
You are wrong on the law. I'm not here to answer your questions or give you legal advice.
I'm not asking for legal advice. I'm asking for a decision from the bench. Are you recognizing the Constitution is subordinate to a statute?
No. What I am saying is that we are not here at this time. This hearing is not about whether the indictment is valid whether there is a basis for dismissal. What we are here about is your detention. Do you have any evidence?
And that's what this is about. The detention is I'm only detained because of this sheet of paper, which has said it's to be an indictment for interstate commerce, which the Constitution says they don't have a right to regulate me at any point.
That is your position on the law. You are incorrect. Any additional evidence besides legal argument?
Yes, ma'am. The Constitution for the United States is the evidence. In Article 3, Section 2, all cases affecting ambassadors, the Supreme Court shall have original jurisdiction. In Article 6, all treaties made under the authority of the United States shall be the supreme law of the land, and the judges shall be bound thereto and shall be bound by oath to support the Constitution of America.
And that is what I'm doing.
If you
I'm
are not,
giving you an opportunity to give me evidence to support your claim that you should not be detained.
I just did. I think I clearly showed that it's undisputed that I'm the ambassador of the Chilcotin Nation. The Montevideo Convention clearly articulates United States of America. Would you like this, ma'am, as an exhibit? I've got a copy of the Convention.
I think I have several in front of me that indicate that you are of that position with that nation, yes.
Yes, ma'am, and it's undisputed, and the United States of America signed on to these conventions for the benefit of the ambassadors of this government's interests, so that their ambassadors can go abroad safely and return safely, and that's what we want. We want to have the ability to have peaceful relations so that our spokespersons can go forward and develop these relations between other nations. That's what it's all about.
I am taking judicial notice of the Constitution. I'm taking the judicial notice of federal criminal law. I'm taking judicial notice of your arguments. I reject your arguments as to the meaning of the law and how that law applies to the issue of detention. Anything else?
Well, it has to do with the Vienna Convention that says it's illegal to detain me.
I will take judicial notice of the Vienna Convention. Anything else?
Yes, the fact that even the Second Amendment in the Constitution says the right of the people, and I'm one of the people.
And that's to bear arms. The Second Amendment is to bear arms.
Yes,
Are you
ma'am.
saying that, okay?
I'm saying that it's accusing me of bearing arms as somehow a crime when the Constitution, you can't pass a law circumventing the Constitution. That's exactly what the statute does. And I would say that given the fact that the
You're
Constitution...
again arguing a motion to dismiss. That is not what we are here for today. We are here on the issue of detention.
A motion to dismiss can be heard at any time. It's valid, and right now I believe it's as valid as it's going to get. And you're in a position to dismiss this matter right now and release me.
No.
You have that authority.
I will not do it.
Well, then you're circumventing your oath of office.
I signed the criminal complaint in this case. I know what this case is about. There's probable cause to believe that you committed a federal crime. Now the next question
there was no
is there
preliminary
a
hearing on this
reason?
matter. You're prejudiced, Your Honor, on this matter because if you signed the preliminary hearing probable cause, you shouldn't even be hearing this matter. That makes you prejudicial because you've already made a determination on your own and you're not going to go against your own determination, obviously.
Your motion to recuse is denied.
There is an Amendment 8. Excessive bail shall not be required. There's no victim in this case. We're talking about somebody accusing me of traveling across the country with something that I know nothing about, that nobody can identify, that I have anything connected with it. And they say that they didn't get into this airplane until 3.5 months later. This is interesting that in America, where we're supposed to be free until proven guilty, I would say that this court has enough evidence to not only dismiss this case, but certainly enough to order my immediate release. And given the fact that this court actually has the authority to reference this evidence before them to the state of Tennessee, that an insane notion that somebody can be sentenced to prison for 3 years for failure to appear when they were never given a lawful notice to appear in court is insane. And this country can do a lot better. The last thing I would mention is that under the necessity of me being here is that I'm brought here against my will. I was thrown to the floor 2 days ago when I was brought in here because this is against my will. I don't consent to this. My giving you information in no way confers jurisdiction upon this court because I don't know the form of court. I've asked. You have not answered it directly. I don't know what rules apply. I have not been represented or provided proper legal counsel at any point. I have only spoken to Mr. Vanderslipp for a total of 4 minutes, moments before being brought here on Monday, and then today we talked about many things, but for the most part about him wishing to withdraw from the case simply because various reasons he is not interested in the case. And I certainly believe that I would much rather have legal counsel as the Constitution requires and not someone who's possibly being pressured by the court to maybe not give as good an assistance as one might otherwise. But I certainly don't consent to some notion of a sidebar armchair counsel, which I am not an attorney. I am not a lawyer, and I have
already, if you'll listen for a moment, I've already advised you. I interpreted the other day when I said you have not requested counsel. You responded to that question by saying, I demand all my rights. I interpreted that to mean that you wanted counsel. Today, I was advised by Mr. Vanderslice after I appointed him that you would not permit him to enter an appearance in this case if that were to be interpreted as that you were conceding to the jurisdiction of this court. Mr. Vanderslice wanted to withdraw. I granted his motion to withdraw and advised you that if you want appointed counsel, you have to, appointed at no cost to you, you have to complete a financial affidavit, and after you do so, I will look at it. I will assume that if you complete the financial affidavit, that you are thereby requesting appointed counsel. If you do not complete that financial affidavit, and my courtroom deputy will give you a blank copy of that after we are done, I will assume that you are not asking for free counsel. That does not mean that you cannot hire counsel on your of your own from wherever you want to hire them. It is simply saying that I cannot appoint you counsel unless you either ask for it or I can imply that you want it because you filled out an affidavit. That is what I'm trying to tell you. Right now, Mr. Vanderslice is seated with you as standby counsel because you would not let him enter an appearance in this case, because you said that that would be interpreted as acceding to the jurisdiction of this court. That is where we are. You now have been told, as clearly as I can say, what the rules are on getting counsel. You'll get the affidavit that you can complete if you want me to appoint someone to represent you. But you're going to have to allow that person to enter an appearance in this court. If you do not let them enter an appearance in this court, then they can't represent you. That is the rules of our court.
I'm not looking for representation. I'm looking for legal counsel.
Well, that's the same thing.
No, ma'am, it is not. It's totally different. But what I want to make a point of, Your Honor, is that given the fact I've been locked up in a jail cell for almost a year now pertaining to an arrest warrant that the gentleman mentioned earlier, and that's what I was looking for, because I've never been given this arrest warrant to know the cause and nature of that original arrest. I would love to see the original arrest warrant. I've never been provided. I was arrested without a warrant.
You have a copy of the indictment in front of you.
That's not the arrest warrant. I need the arrest warrant. You can't start an indictment without a complaint. You have to have a complaint. And I've not been shown do we have an affidavit of complaint on file?
No, because I was incorrect before. I did not look at this on a criminal complaint. I looked on it on another matter. There wasn't a criminal complaint, and there need not be a criminal complaint in federal court. It can begin with a grand jury indictment. In this case, Evidence was presented to a grand jury, and it began as a grand jury indictment. Am I correct on that, Mr. Sharp?
You are, Your Honor.
Thank you.
And
you do have a copy of the indictment in front of you.
Does the grand jury in Nebraska's federal court system not require a signed affidavit by anyone giving testimony?
It receives testimony live. There's no affidavits.
No documentation. So there's no. Do you record these people testifying? Because I'm going to challenge this indictment because I don't know who's making this indictment. I don't believe it's valid, and I would request this court provide me a transcript of that.
I am trying very hard to give you all of the due process you're entitled to, but you will not listen. This hearing is about whether you should be detained. It is not to challenge the indictment itself. That is a whole different matter. Based upon the evidence that is presented in front of me, I do find that you are a risk of flight and a risk of danger to the community if you are released.
Objection, Your Honor. There's not any evidence before this court that I'm a danger to anyone or a flight risk. I've appeared in court every time I've been ordered to be in court, without exception, and I've never harmed anybody in my life. And there's no facts presented to this court about anything.
You may appeal my decision if you wish. That is my decision. You will get a written copy of my order explaining that decision. And, of course, you may appeal it to the district judge who is assigned to this case, which is Judge Gerard. That brings us to the motion to compel at this time. Mr. Sharp.
Your Honor, the United States calls Aaron Crooks to the stand.
All right. Aaron.
Please state your full name for the record, spelling your last name.
Aaron Crooks, Crooks.
Raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
You may proceed.
Who do you work for, sir?
The U.S. Marshal Service.
What's your occupation?
I'm a Deputy U.S. Marshal.
How long have you been so employed?
7.5 years.
What do your duties consist of in that position?
We work... we're the enforcement hand of the judiciary.
Your Honor, I object.
Do you also...
I'm sorry. Your Honor, I must object. There's a page on here that I was not given an opportunity to review before you proceeded on, and you kind of caught me off guard there. This back page on this thing, it's saying that I have a criminal association.
I have no idea what you're talking about. I have ruled. We are moving on to the next topic.
But I've been denied the right to review the information prior to your rule. You got me off track there talking about the other things. I was given a basis for my release because the court lacks jurisdiction, and you didn't give me an opportunity to review this. The last page is making statements where there's no basis for the statements.
Are you talking about page 5 of the pretrial services report?
Yes, ma'am.
Those are the opinions of pretrial services. I do not
Based on what?
I do not take those opinions into
I would call the pretrial services to the stand to get testimony in this matter because I've not been heard. This matter is news to me. I just saw it. I didn't see it before, and I would challenge it point by point because none of this is true. I don't have a violent history. I don't have any criminal association. This is ridiculous. There is no pattern of criminal active behavior. I've worked since I was 14 every day of my life, have a wife and a farm, and don't jeopardize any of that. Because I present to people the necessity of standing up for the Constitution, if the Constitution is a detriment and a danger to this government, then that's not my fault. It's the government's fault for being rogue. But I don't see why I should not have an opportunity to challenge this where
it's only valid to challenge it if I considered it.
You considered
I don't consider the pretrial services opinion.
You made the statement that I'm a flight risk and a danger to...
That was my independent decision.
Based on what?
I will put it in my written order. I will not go into it any further right now. We are late in the day. I will put it in my written order. You are entitled to a written order under the Bail Reform Act, and you will receive a written order. At this point in time, we are moving on to the next hearing.
Can I then, for the record, then assume that you did not consider page 5 as relevant at all in your decision?
I did not consider page 5 as relevant at all in my decision.
And is there anything outside of what's been presented in this that you considered other than testimony here today to make your decision?
Other than the testimony that we received today, no.
Have you been in contact with any other judicial officers regarding this matter?
No.
Judge Walker of Tennessee?
I have no idea who he is. All right.
Mike Donovan, the District Attorney of Tennessee?
I've never talked to anybody in Tennessee about this case. I have no idea. I don't know who those people are. All right, Mr. Sharp, you may proceed.
Do your duties also involve transporting prisoners and taking them from court and to detention facilities and vice versa?
Yes, they do.
Do you know an individual by the name of Michael Wayne Parsons?
Yes, I do.
How is it you know him?
Mr. Parsons was brought into the Marshal Service holding for court on, I believe, the 18th of December.
Are you talking about Marshal's Service custody up here in the state of Nebraska?
He was brought up to our facility for his first court appearance here, yes.
Okay. Is it correct that he was actually picked up on a writ from the state of Tennessee?
Yes, he was.
And is it also your understanding that he is serving a state sentence down there?
I believe so, yes.
Now, does the United States Marshal Service have any policy that has been issued that requires medical testing of people who are being detained?
Yes, they do.
Do you have exhibit number 1 in front of you?
I do.
Can you identify what exhibit number 1 is?
This is the U.S. Marshal Service policy 9.6 detailing prisoner airborne pathogen control.
Okay, and have you reviewed this policy before?
I have.
And is this, in fact, the current policy that's in effect for the United States Marshal Service?
Yes, it is.
Do you know where this was obtained from?
This was obtained off the U.S. Marshal Service intranet and basically our policy manuals online.
Does this particular policy discuss tuberculosis testing?
Yes, it does.
And does it also discuss procedures on how to administer such tests and what to do if a detainee refuses to submit to such testing?
Yes, it does.
Your Honor, I would offer Exhibit 1 at this time.
Any objection?
Objection.
And the basis of the objection?
I don't have the exhibit.
It's right here.
This does not, I've scanned through
I
this.
need a basis for your objection.
It doesn't incorporate into it the United States Supreme Court decision regarding the Title 42, 2000 BB, the Religious Freedoms Restoration Act, which clearly exempts people of religious convictions, Native Americans specifically, but it incorporates other religions too, whereby it specifies that where there is a rule of general applicability, meaning that it applies across the board, there's an exception when it refers to religious freedoms. And in the case of TB test or flu shots or anything else, I am exempted from taking those because it is against my religion. And the fact is that the United States Supreme Court recognizes that I have a right to my freedom of religion, and I do not do the TB shots. I've never done any of these things simply because the manufacturer stipulates they don't guarantee the safety or effectiveness, and I don't take chances with my body. I don't stick needles into my body. I don't do Western medicine. I'm naturopathic, as you have as an exhibit that I am a ordained minister in the Native American Church in the Menha, which is strictly forbids the use of chemicals, drugs, Western medicine, any of that. We utilize natural remedies, which is the basis of all medicine. And the Supreme Court went on to rule and talk about this, and that they said the penal facility's interest in maintaining a safe environment goes to the extent that they
Sir,
can
what is
isolate
your
you.
objection?
Ma'am?
What is your objection?
This does not include all the information relating to the cause of TB.
It may be incomplete in your opinion, but it is received. Mr. Sharp, you may proceed.
Does the policy, just for purposes of helping people navigate this document, if I could refer you to the first page, subsection D2, does it indicate who it is that is to administer any such tuberculosis testing?
Yes, it does.
Specifically, who is to do that?
A healthcare professional.
Does it indicate when it is the person is supposed to be tested once they come into U.S. Marshals policy?
Yes, it does.
And when is that in relation to when they come into Marshals custody?
As soon as possible, but no later than 14 days.
And then directing your attention to page 6 of the document, specifically section 10 B1, does it indicate how the test is administered?
Yes.
Specifically how?
It says TST, PPD, or Mantoux tests should be administered to every prisoner upon admission.
In fact, does it indicate that that is done by an injection under the skin?
Yes.
Is it correct that sometimes detainees or prisoners refuse to submit to a TB test of that type?
Yes.
Does the policy also set forth how that is supposed to be handled?
It does in section E5.
Is that on start on page 3 of the document?
Yes, it does.
And just looking at going over on to page 4, is it correct that there is an alternative that is available to the prisoner if they don't want the injection?
Yes, there is.
Specifically under C, what is the alternative that is offered to the prisoner?
A chest X-ray. A chest X-ray.
Now, you've indicated that you know Mr. Parsons, correct?
Yes,
Have you reviewed his case file?
I have.
Objection.
Overruled.
Do you, from your review of your case file, do you know whether or not he has been approached about submitting to a tuberculosis test since he came into U.S. Marshal's custody?
He was asked on the 13th of December.
Okay. By whom?
The nurse or the medical staff at the Saline County Jail.
Did he agree to submit to that testing?
He did not.
Does his file indicate he has ever undergone any testing at all?
It shows that he has not.
Where is he currently being held?
In Saline County Jail.
Okay, that's county jail, is that right?
Yes, it is.
Is that a contracted facility for the United States Marshal Service?
Yes, it is.
Do they nonetheless follow the federal standards in terms of tuberculosis testing?
Yes, they do.
He has not been tested for tuberculosis. Has that resulted in any alterations being done in terms of where he's being held at that facility?
He's not in general population. He is in a singular cell, I believe, in segregation.
And is that due to his refusal to submit to TB testing?
Yes.
Is it also correct that he had refused to submit to TB testing when he was first taken into custody in the state of Tennessee?
I believe so, yes.
Was any special dispensation made to get him up here as a result of his refusal?
Yes, it was.
What was that?
He was transported. Normally he would have been transported via JPATS, probably flown up here. He was transported by van up here. And I don't believe he had any contact with any other prisoners.
I have no other questions, Your Honor.
Cross-examination.
When was I taken into custody by the U.S. Marshal Service?
Where?
When?
Which
day? When was I first taken into the custody of the U.S. Marshal Service?
I am unaware of that exact date. Are you talking here in Nebraska?
No, sir.
Transfer of custody to the District of
in
Nebraska?
Tennessee.
I do not know what day. I would have to look back at the computer.
September 27th, 22nd?
I do not know.
September 22nd is the date.
Okay.
Are you aware that I was taken to the West Tennessee Detention Facility and held there since September 22nd until December the 13th?
I know that you were held in Tennessee. I don't know where the facility was.
And that is a U.S. Marshal Service contracted CCA Core Civic facility, West Tennessee Detention Facility.
I don't know if that is or not.
Do you know if the U.S. Marshal Service uses CCA Core Civic facilities for holding facilities for detainees?
We do.
Thank you. And you have no record of the time that I was there housed in and amongst other people that after 10 days they realized that I don't have TB and I was allowed to go throughout the facility for over 2.5, almost 3 months.
I have no record of that.
For 3 months I was in the system with no TB test because they recognized that I'm not symptomatic and they recognized my religious convictions.
I don't
Then
have
I was Are you aware that I was moved from there to Leavenworth, Kansas?
No.
How did I get from Tennessee to here?
I don't know the exact route you took. I don't
Okay.
know who was involved in the transport. I just know it wasn't us.
Okay. If I'm transported from Memphis or Mason, Tennessee, actually, to Leavenworth, Kansas, with drivers and passengers and so forth, and there I'm in a room and I go out in the vicinity just as everyone else does, being housed in segregation, one-man room, with other men in one-man room. They all get out and go take showers. I take a shower when everybody else is taking a shower, go the various things that they have. As we are right now, proximity, Mr. Vanderslip is right here beside me. He seems quite calm about being in the vicinity of someone who hasn't had this TB test. I would think that if he was concerned, that he would certainly probably not be so close to me.
Your Honor, I object to the form of the question not being a question.
Sustained.
Are you concerned about me being TB at this point? I mean, you brought me in here the other day at close quarters, correct?
I bring a lot of people in. If you have tuberculosis, I get tested every year for tuberculosis. So it's very likely if you have it, then I'm going to catch it.
Are you familiar with the religious exemption of TB?
No.
Are you familiar that TB has symptoms of fever and persistent coughing and such that make it readily apparent when people are symptomatic? That's when they're contagious. That people who have TB don't necessarily test positive, nor do they demonstrate symptoms, nor are they symptomatic. Are you aware of that?
You didn't make sense to me there.
There are people that have TB
Okay.
that actually have no symptoms.
Okay.
And when they're tested for TB, it won't show up. But they are a carrier because the test is not effective, nor is it safe, according to the manufacturer. I'm just going by the manufacturer. Have you ever studied the insert to see who the manufacturer farms out the manufacturing of this to when they run short?
Objection, relevance.
Well, the relevance is that there's no checks and balances in the consistency of the pharmaceutical company that manufactures it, and because of that, they're utilizing adjuvants such as squalene. Are you familiar with squalene?
No.
The objection is sustained.
The reason is that you need to know for your own consideration that squalene causes Guillain-Barré syndrome, which is paralysis. And if they don't have that, they put thimerosine in it, which is mercury, which causes brain damage and early onset Parkinson's and other types of neurological problems, as well as Alzheimer's. Those are the side effects you can get from taking an unknown and unsafe testing chemical known as the TB test. And I do research.
Your Honor, I'm going to object again to the defendant testifying.
The fact is
questions.
Sustained. Ask a question.
The fact is, you don't really know me at all, do you?
I just know you as a prisoner in our cell block.
But you don't know me. You just escorted me in the other day, correct?
Correct.
Okay. Actually, yanked me in and threw me to the ground. Is that correct?
I forced you into the courtroom, yes.
Okay. And given the fact that if I move from Tennessee with drivers and passengers to Leavenworth, here again I'm around inmates and they realize I'm not symptomatic and they've done their research and they realize that, okay, he's right.
Sir, you must ask a question. You are not
Are you
permitted to
familiar
simply
with-
testify.
Okay. Are you familiar with Title 42, Section 2000 BB, the Religious Freedoms Restoration Act?
No.
Therein, the Supreme Court ruled that under rules of...
Objection to the defendant testifying. The witnesses said he doesn't know that anything about that statute.
Sustained.
If he is testifying as the expert for the state regarding this,
He isn't.
he may have heard about it.
He isn't testifying as an expert. He's simply stating that this is the policy of the facility.
You have lots of policies that you go by. Have you ever come across a policy where the Supreme Court ruled that your policy is illegal and you stopped that policy?
No.
You've never stopped a policy.
that's not what you asked me.
Have you ever had a policy that you had that was stopped for some unknown reason?
We have updates to policy all the time.
All the time. And the reason they're updated is because laws change.
Laws do change.
That's right. The Supreme Court makes decisions all the time which affect your policies. And in this case, when was this published? I see there's a date here at the bottom. It's effective 2010. Okay. The Religious Freedoms Restoration Act was responded to again in 2012 by the Supreme Court, further enforcing the fact that people of the Religious Freedoms Restoration Act was...
And I'm going to object to this as not being a question posed to the witness.
I'm giving the gentleman some background. He may have a recollection of hearing about it. 2012.
You're well beyond the scope of the direct examination at this point, because all he testified about on direct examination was that this is the policy of the Marshal Service, asking him about how it fits with current U.S. Supreme Court law. He is not a witness as to that issue, and he did not testify as to that issue on direct.
So you would say that you're not qualified to respond to what the Supreme Court's position is regarding the forcing of a TB shot on someone whose religious convictions are opposed to that?
No.
Okay. Nothing more.
All right, you may step down. Oh, wait, did you have any redirect? I'm
I was
sorry.
just going to say nothing further, Your Honor.
Okay, you may step down.
I have nothing further, Your Honor.
All right. Any evidence, sir?
Your Honor, the court shall take judicial notice that under the Title 42, Section 2000BB, the Religious Freedoms Restoration Act, this was stemming from a lawsuit with the Native Americans of the United States regarding abuses against the indigenous peoples for well over a century. And the United States Supreme Court and the World Court came to a settlement agreement that they would recognize the religious freedoms of all Native Americans worldwide, allowing them to partake in their customs and traditions, including natural medicine. You may have remembered at that time when this was passed that all of a sudden there became a bumper crop of peyote plants being harvested and manufactured and sold, and a lot of people were being prosecuted. The Vigueros case in 2011 in New Mexico, where they were all lily white people, as the Supreme Court, or Alberto Gonzalez said, they're all lily white people. They're down there doing ayahuasca, getting tripped out on ayahuasca. And Justice John Roberts said, no blood quantum required, because they're practicing a Native American tradition. Though they may not have one drop of blood of Native American descent in them, it's their right to practice their religion as they see fit, and they were case dismissed of a Schedule I drug. Case in point is that there is support by the Supreme Court time and time again for the Religious Freedoms Restoration Act pertaining to indigenous peoples and practitioners of indigenous religions to practice their religion. I have never had a TB test. I do not consent to it. This is my body. You have the credentials that I am a ordained minister in the Native American Church of the Menha. Anything forced upon my body is my temple through which I do my ministry. Forcing any unknown substance into my body against my will is considered cultural genocide by not only the Supreme Court, but the World Court in The Hague.
All right.
I object to being forced to take anything that is unnecessary, and I have demonstrated I am not symptomatic. All of these facilities have no problem with me. Right now where I'm housed, I'm right there at the guard station. They sit there and talk to me all day long. They're not the least bit concerned, even the nurse. They've gone to my website. They know this is a railroading. They don't like it either. I would move that this court allow me to preserve my body because I don't consent to it, and it's unnecessary, and it deprives me of my God-given right to preserve my body through which I do my ministry.
All right, I will take judicial notice of your comments. Anything further from the defendant?
I think the Supreme Court's decisions has spoken clearly that they recognize the rights of all people regarding their religious freedoms pertaining to forced inoculations. Even the nurses who've argued against being forced to take flu vaccinations prevailed in the Supreme Court. And I'm just one man standing before you today asking that you recognize my rights as a human being and an American, and as a Native American, respect those rights and customs that I have practiced my entire life and not force upon me, because I will not consent. And they will have to hold me down, and they will hurt me. And if you wish to order additional harm against me, that is something that I can't prevent, but they will have to do this by force. And I am in very poor health. I have had 3 broken ribs that are still healing. The doctors notice that you've got a test of that. I'm not a violent person, but I will protect myself from harm. I do not wish to be forced medicated with anything that is against my will. It is inhuman.
All right.
I ask the courtesy of this court to respect my religious freedoms.
Mr. Sharp, anything you'd like to say?
In terms of argument, Your Honor?
Yeah, I believe we're on argument now.
Yes, Your Honor. The court had identified at the last hearing Turner v. Safely as being the case that would likely govern the court's analysis of this regulation, and I agree. As I read Turner v. Safely, it appears to me that there are 4 factors that the court is to look at in deciding whether or not an institutional regulation can be enforced over objection. First, there has to be a valid rational connection between the regulation and a legitimate government interest put forward to justify it. Exhibit 1 is the U.S. Marshal's policy, and it explicitly says that it is aimed at screening for tuberculosis to prevent the spread of disease. That's referenced on the first page. The Eighth Circuit Court of Appeals has repeatedly held that TB testing is rationally connected to a legitimate government interest. The court has held that in Lee v. Armentrout, and in the other Eighth Circuit case, DeGidio versus Pung. I think I've supplied both of those cites to the court previously. There are also 2 other court decisions that the court had noted, Darby versus Schetzel and Benjamin v. Hobbs, both of which hold that testing for TB is it's rationally connected to a legitimate government interest. The second factor under Turner and Safely is whether or not it's a reasonable restriction and whether or not there are alternative means available to the inmate to allow him or her to protect their interests. In this case, Mr. Parsons obviously does not want an injection. The policy actually contemplates somebody that might object to an injection and allows them to have a chest x-ray in its place. The third factor has to do with whether or not an accommodation of the detainees' inmates' interests would have an impact on guards, inmates, and others. And obviously, I think that's self-evident. If somebody, in fact, is carrying tuberculosis, we are risking the spread of the disease to others. And then the last factor has to do whether or not there's any other alternatives. Well, the only alternative, if you don't want to undergo an injection or to have a chest x-ray, is no testing at all. And that is not a reasonable alternative when you're dealing in a setting where there are all kinds of people crowded together. That's just running the risk of a contagion spreading. I do have one case I want to cite to the court in relation to Mr. Parsons' objections on religious grounds under the Religious Freedom Restoration Act, Title 42, United States Code, Section 2000 BB. I would direct the court's attention to United States versus Myers, 95 F. 3rd 1475, 95 F. 3rd 1475. It's a 10th Circuit case from 1996 in which a gentleman who was the founder of the Church of Marijuana was arguing that he was commanded by his religion to use marijuana. And the 10th Circuit said laid out what the burden is on the person that's asserting a religious interest. And the court held that the person asserting that religious justification must establish by a preponderance of the evidence 3 threshold requirements to state a prima facie free exercise claim. The governmental action must, 1, substantially burden, 2, a religious belief rather than a philosophy or way of life, 3, which belief is sincerely held by the plaintiff. The government need only accommodate the exercise of actual religious convictions. And I would argue that simply asserting that his religion does not allow him to undergo either an injection or a chest x-ray is insufficient. There is no showing in this record on how requiring him to undergo TB testing would violate the tenets of a true religion. That's all I have.
All right.
May I
Response?
respond? Thank you for citing the Myers case. That's an excellent case. This is actually the case that I use in the Tennessee jail in order to not have to take TB shot. That's why all these facilities haven't forced it upon me, because of the Myers case. So thank you. This is a case where the Coptic Church of Ethiopia, the Church of Pot as somebody refers them to, had a truckload or a barge full of pot come into Boston Harbor, I believe it was. They were arrested. And after it was determined that this is a sacrament of theirs, the judge ordered the pot released, and they went on their way. They were released because it was a deeply held religious conviction. I've articulated to this court, I hope, that I don't do injections. Never have. I'm 56 years old. I think that stands to reason. It's a fairly deeply held religious conviction of mine that I don't do Western medicine, period. I have not, in my adult years, I haven't been to a Western medicine doctor, a friend of mine that I occasionally play golf with 30 years ago. I have a letter from a naturopathic physician. I myself don't have the numbers and designation behind my name, but I too am naturopathic trained exclusively in natural remedies. So if you've got hepatitis, I can tell you the natural way to cure it. This is excellent information because I've cited all of these 3 standards. I've met all these credentials in my presentation today. And I had forgot about the Myers case, but it is the landmark case that they establishes. But however, beyond that, the Supreme Court, Justice John Roberts in the Vigettos case, pointed out, and they still rely back on the fact that this is not a life way. This is not a fad. This is a religion. This is part of my religion. And I'm not sure if Your Honor is familiar with many Native American customs and traditions. Friends of mine that are a Seventh-day Adventist, they too practice natural remedies. Consequently, many of them live to be well over 100. As my friend Dr. Joel Wallach says, those people live to be well over 100, and their medical record charts usually find 2 things, a birth record and a death certificate. Those people that tend to die early tend to have these thick records, and in this country, the CDC's own statistics show that the number 1 cause of death in this country, if you add interactions with prescription drugs and botched medical procedures, add those 2 together, that's the number 1 cause of death. Who attributes to those? Doctors prescribe the drugs and do the medical procedures. Dr. Norm Shealy is a friend of mine, former Surgeon of the Year, voted 4-time Surgeon of the Year, brain surgeon. He is also a Native American Menha, naturopathic. He treats people naturally. Totally has moved away from Western medicine. He cures people of diabetes, type 1 and type 2, with tremendous success. I do not have a problem with being isolated, which I have been, and after 10 days, in the TDOC's system, their policy, in the state of Tennessee, the federal system, is that after 10 days, if you're not symptomatic, there you go. I'm not symptomatic. I don't have TB. The fact is TB is extremely rare in this country. It's outside of a few cases coming up from south of the border. there's virtually no TB in this country, like polio. It's a rarity, and they're finding out that polio has other, how would you say, marketing techniques where they've actually put the polio virus back in some of these viruses to get polio back into the environment. They say it was to stimulate people's immunities. By humbug, it was to create a drive for the polio vaccine to generate profits. Just like Bayer Pharmaceuticals putting Factor VIII out in Africa with AIDS virus, and they were sued and they paid out millions, but they made billions. It's all about profits. The TB is no different. A manufacturer that manufactures these makes money off this. It's all about money. I, for one, don't want to be a statistic with paralysis or memory loss because heaven knows there's too many other things out there causing memory depletion in the environment, in the population. It's a tragedy. The statin drugs, the CDC admits now that they're the number one cause of Alzheimer's. Reduces the cholesterol, which your brain sits in a pool of cholesterol. So I know this stuff. I'm asking you to recognize the Religious Freedoms Restoration Act and the fact that the Myers case, if you review it, excellent case. I've met all of these standards and beyond. I've never done this test. I don't continue to do it now. None of these institutions have had any problems with me. As a matter of fact, they had me coming out of my one-man room and going down and assisting other inmates in West Tennessee that needed help on the computer because they didn't have computer skills and they needed help. And so I assisted many men in that. I spoke at length with the chaplain there about assisting them in religious aspects that a lot of these young men that get in there, they don't have a religious background. And so they might interest in certain areas. And I'm the only guy in the unit that has a background in Native American and other religions of the world. And so I can talk to them on various levels if they had an upbringing in certain types of religions. And that's part of my ministry, is trying to help people where they're at so that they can benefit from the blessings that God has given us. My blessing is my body. I wish to preserve it. Please allow me to continue in my ministry and in my religious beliefs and practices, which is non-invasive medicine. And again, if these people thought I was a detriment, even the nurse said, he doesn't have TB. I don't. I'm not a carrier.
All right. Ms. Bierbauer, may I have the exhibits?
Yeah, approach here.
Yes, you may. The exhibits from the initial hearing.
And ma'am, just to reaffirm, if I may, under the Religious Freedoms Restoration Act, it says where there's a rule of general applicability, and I guess we can all stipulate their policy is a rule of general applicability, meaning it's across the board. In those cases where we have these three criteria met, then the religious conviction is respected and the individual is allowed to practice that religious conviction. Even to the degree that in the prisons in Tennessee where smoking apparatus and matches and such are not allowed, the Native American religions are allowed to do smudging, which is where they burn various sages and various grasses and do a ritual called cleansing and smudging for the purification of the spirit. And this is another Religious Freedoms Restoration Act where there's a rule of general applicability where nobody can have matches, let alone smoking materials. They are provided that for their religious conviction and practice.
All right. I'm going to assume for the purposes of the argument that today that you have demonstrated that taking a TB test, the injectable TB test, is a burden on your free exercise of rights, and that it would be a violation of the Religious Freedom Act. If I were to, even though I assume that, a government may substantially burden that exercise of religion if it demonstrates that the application of the burden to the person is in furtherance of a compelling government interest, and it's the least restrictive means of furthering that compelling government interest. In this particular case, we are dealing with a population of people that are housed in a closed environment. Tuberculosis is a very harsh disease. It is highly contagious and can have far-reaching and devastating effects on people. If it is not aggressively tracked, it can spread from one person to another, particularly in the closed setting of a prison. People inside of a prison are sometimes people who are natural targets for this disease, people who have had HIV, AIDS, those types of things. It is a serious threat. The Eighth Circuit has determined such. They have said that tuberculosis inside of a prison system is something that the prison system is required to ward against and is required to monitor to avoid harm to the rest of the population, including the guards within the prison system. And so when I look at your determination and your convictions on a religious basis, I have to strike a sensible balance between you and what you believe and the competing government interest in this case. In striking that balance, I do find that the balance weighs in favor of the government. You will be required to have a tuberculosis test. It will be up to you to decide whether it is the test that requires an actual pinprick or needle prick, or if it will be an X-ray. But you will be required to do one or the other of those, and that is in furtherance of the government's interest in avoiding the spread of tuberculosis within the prison system. Anything that else we need to take up?
No, Your Honor. I would like to respond. I don't consent to that, and I wanted to know to the degree, are you going to order this with force to the degree that my bones are broken or death? How far do you want to go with this, Your Honor?
You will be. I am telling the marshals that they are permitted to impose the test. The degree to which it harms you is in part based upon how you respond.
I will fight to the death.
All right.
This is my life, this is my body, and you don't have a right to rule over my body. You don't. You don't have jurisdiction over my body, and that's something you don't have a grasp of, ma'am. Because you have a position as a judge ruling over people that come before you, you do not have the first inkling of the rights of a human being to freedom of religion. You've just demonstrated that. Now,
I
if you
have
want
an
me
understanding
dead,
of the law.
you just
I have
sentenced
made
me.
my ruling, sir, and it is not subject to any further debate.
Well,
we
I
are
need to
in
know
recess.
if you're sentencing this to be up to including death so I can have my